Well, I simply have to now to give the floor to a member of the arbitration court, Natalia Pavlova. Uh, uh, Natalia, let's talk about specific issues in the legal practice. Tell me, do you get phone calls a lot when they call you and tell you what ruling you have to make? Well, this is not a provocative question. It's really a very frequent question that I'm asked. Well, as a matter of fact, I haven't been around for a very long term. So far, no one has called me and tried to tell me what ruling I have to take. But we also have journals for registration of such things. Now a question about the Russian legal system and law application. To what extent do you believe that both Russian investors and foreign investors are equal before the law? And the first thing you really recall that comes to mind, that if Russian investors prefer to go to court in London, then what do foreign investors, what should foreign investors think? Where are they supposed to go to which court? Well, if we are to analyze the current situation, and it's true that many businessmen prefer to go to London court or to London arbitration, if we come to think about it, we will understand that there is actually a whole set of factors that determine the court jurisdiction that the parties to a contract should choose. Quite naturally, the judicial competition can be compared to business competition. The arbitration court is, of course, concerned with this situation, and we do a lot to try to make sure that Russian arbitration gains more significance and more trust on the part of domestic businessmen. Can I now try to identify the strengths and the benefits that our arbitration system has in front of all potential skepticism that some of you among the audience might feel. And we will also talk about the weaknesses of our arbitration courts and arbitration legislation. Well, going back to the strengths of our arbitration and court system is its specialized nature. There are not so many countries in the world that have specialized courts for business arguments. Business conflicts. I think it's one of the achievements of the Russian judicial system that we now have special courts, special arbitration courts for reviewing and for business conflicts and business arguments. And it's not probably true that absolutely all businessmen prefer to go to London, and that includes foreign investors, foreign businessmen, because just recently we had a number of cases where one of the litigating parties was a foreign businessman, foreign investor. And the system has become much more transparent, and there are not so many countries in the world that can that show a similar degree of transparency. Maybe just the United States and Singapore. And the novelties that we are introducing, especially in the electronic system, I can tell you that it's one of the most progressive systems that we've seen across the world, because naturally enough, we looked into the best practice available elsewhere before we made decisions on what we do domestically. Then the legal procedures, I believe, also are quite decent compared to our many of our counterparts elsewhere. The procedural code that we have is one of the best in Europe, and it provides for quite a fast-paced procedure. Nowhere in the world can you go through 4 court instances in 1 year. And this is probably a result of an assimilation between legal systems and the trend that we are now increasingly seeing, that Russian legislative system and Russian judicial system is becoming more focused on case law, on precedents, which means that any judge, be it in the Primorsk region or be it in Kaliningrad, can press a button and get access to all the case law that has been formed to date on a certain set of issues or on a certain problems. That applies to defendant lawyers as well, who also take part in the formation of case law, because they are the ones who can best see the problems that have arisen, and they also have the right to propose a certain ruling to the judge that is based on case law, based on any precedents that have taken place in the past. They can refer to any approaches that the Supreme Arbitration Court has, and can I reiterate that the Supreme Arbitration Court is involved in a great deal of analytical work. We have a special section set up, a special department set up for that, analytics department, that is involved in analyzing all the precedents, all the rulings that have been taken to date on particular issues, like, for example, on property, intellectual property issues, intellectual property cases, both in Russia and elsewhere. In terms of, for example, protection of domain rights, just a few years ago, the first precedents have evolved at the level of the Supreme Arbitration Court, and at the same time, similar precedents arose in the rulings of the Supreme Arbitration Court in the United States and in Germany. And that uniformity allows foreign investors to track the legislative, the judicial history, the arbitration history, and the case law available to date, and to base their decisions on their findings. And if they can see that low-level arbitration courts are not following the precedents or the guidelines set by the Supreme Arbitration Court, they can file a claim with the Supreme Arbitration Court on the subject that the rulings, the corresponding rulings taken at the lower level of the arbitration system should be revisited and perhaps revised. I agree with the previous speaker that a lot needs to be done in terms of ensuring court independence, and there are also quite a few other issues that are currently on our agenda, whereas but they are rooted in a different subject. And I'm talking about the a subject of legal reputation, both both for the lawyers representing companies in court cases and the companies itself. We very often see that foreign companies can bring in our jurisdiction something that was recognized as a malpractice back in their jurisdictions back in maybe 10 or even 20 years ago. So some of the practices might have been abolished in their domestic jurisdictions, but for some reason, foreign investors on some occasions are trying to bring those practices into the Russian arbitration context and into the Russian jurisdiction. So clearly, companies shouldn't try to sidetrack the available rules and regulations and available arbitration case law. Just recently, I think we found that a number of international banks, of foreign banks, provided services in the Russian Federation without being legally established in Russia and without obtaining the necessary permits from Russian banking regulators, and they did that through a number of pocket entities. So there are such practices that call for a particular attention on the part of the Russian judicial system. And it all can be tracked again on the basis of open and transparent systems that Russian courts and arbitration authorities need to take on board. We have already taken a few attempts to think about the issue of the involvement of professional lawyers in court cases, maybe even a certain monopoly of lawyers, that only the established lawyers that are part of the bar can take part in the legal process in the court hearings, so that the outcome, the result, the final result and the final quality of arbitration proceedings and court proceedings could be raised to a new standard. And as a general observation, can I also note that perhaps I don't think international investors should be all that scared of our court and arbitration systems, because the stats demonstrate that foreign companies win about over 60% of cases in our courts. Does that suggest the better knowledge of the legal system, or simply they've got better lawyers? Well, as a matter of fact, companies do tend to involve very highly professional defendant lawyers when it comes to the question of potential loss of property, loss of assets. Foreign investors do tend to involve very high-quality lawyers, professional lawyers. Natalia, I'm not a lawyer. When you talk about a judicial reputation of a company, what does that actually mean? Is that something like a credit history? Is that a track record that the company has got with courts? Yes, exactly. As I said, our electronic system is quite accessible. In the sense of the stamp duty that you have to pay. Our court is one of the cheapest courts in the world. You all know of a recent court hearings in the London High Court, and you will probably know who I have in mind when I'm talking about this multi-billion case, multi-billion lawsuit. One of the reasons I think the parties decided to terminate further legal proceedings in the court was that it appears to be quite costly, and it's different with us. As a matter of fact, on a number of occasions, you will see that the parties go into the four instances on the four tiers of the court system, put forward the same grounds, the same arguments in favor of the lawsuit, whereas each tier actually has a different objective and a different role to play. We are, as a Supreme Arbitration Court, mostly involved in the general issues like the violation of the established public order, infringing on the interests of society as such. On the other hand, sometimes we can have applications, we can have cases filed with the Supreme Arbitration Court from businessmen who have gone through previous instances through the first hearing and then through the appeals arbitration court, and they are still trying to prove that the low instances of arbitration were not did not take the correct rulings.
See, this topic has been assessed very closely over the last years, and partially thanks to our Superior Arbitration Court, because even 5 years ago, the fact that the legal costs, they are actually costs. You can judge by the name. It's very costly, mainly because their counter-agent in court just did not play a fair play during the proceedings. I mean, a person might believe that he or she is right, but he or she might not behave the proper way in a court. And that is exactly what caused the loss in a court. So you have to hire a lawyer, you have to spend certain costs on some experts' conclusions, both legal and industry specific, or something like that. But as for the compensation, well, it rarely gets compensated. At least not in full volume. It's just that the dominant approach, and I'm sorry to disturb you, but to interrupt you, but now the main issue is the criteria of surplus, criteria of extra costs. The main principle is not to pay extra. You see, if your counter-agent does not object and it does not say that that the expenses are not extra, then the court should not interrupt the relationships between the agents in the court. It should satisfy the demands of both prosecutor and the defendant. And the second thing is that before, several years ago, we thought that it's some kind of a processual benefit, and it was not written anywhere that court costs and legal costs should be compensated. You see, it's a part of material law, property law, because when you take something from a person in a court, then it should be compensated further on.